Welcome back to Knowledge is the Power. Friends, in this video, we will discuss on the topic CCS CCA Rules 1965. Particularly in this video, we will discuss on Part 7 of CCS CCA, that is Appeals. In that, we will see rule number 22, that is orders against which no appeal lies. Rule number 23, orders against which appeal lies. Rule number 24, Appellate Authority. Rule number 25, period of limitations of appeals. Rule number 26, form and contents of appeal. Rule number 27, consideration of appeal. Rule number 28, implementation of orders in appeal. Now we will see one by one. Rule number 22, orders against which no appeal lies. Notwithstanding anything contained in this part, no appeal shall lie against any order made by the President, any order of an interlocutory nature or of the nature of a step in the final disposal of the disciplinary proceeding other than an order of suspension, any order passed by an inquiry authority in the course of an inquiry under Rule 14. Next, rule number 23. Orders against which appeal lies. Subject to the provisions of rule number 22, a government servant may prefer an appeal against all or any of the following order, namely an order of suspension made or deemed to have been made under Rule 10, an order of imposing any of the penalties specified in Rule 11, whether made by the disciplinary authority or by any authority or revising authority. An order enhancing any penalty imposed under Rule 11. An order which denies or varies to his disadvantages his allowances, pension or other conditions of services as regulated by the rules or by agreement, interprets to his disadvantages the provisions of any such rule of agreement, an order stopping him at the efficiency bar on the time scale of the pay on the ground of his unfitness to cross the bar, reverting him while officiating in a higher service, grade or post to a lower service, grade or post otherwise than as a penalty, reducing or withholding the pension or denying the maximum pension admissible to him under the rule, determining the subsistence and other allowance to be paid to him for the period of suspension or for the period of during which he is deemed to be under suspension or for any portion of thereof, determining his pay and allowances for the period of suspension, for the period from the date on his dismissal, removal or compulsory retirement from service or from the date on his reduction to a lower stage, grade or post, time scale or stage in a time scale of pay to the date of his reinstatement on restoration of his service, grade or post, determining whether or not the period from the date of suspension or from the date of dismissal, removal, compulsory retirement or reduction to a lower stage, grade, post, time scale or pay or stage in a time scale of pay to the date of his reinstatement or restoration of his service, grade or post shall be treated as period sent to on duty for any purpose. Next, rule number 24, that is Appellate Authority. A government servant, including a person who has ceased to be in government service, may prefer an appeal against all or any of the orders specified in Rule 23 of the authority specified in this behalf, either in the schedule or by general or special order of the President, or where no such authority is specified. Next, rule number 25, period of limitation of appeals. No appeal preferred under this part shall be entertained unless such appeal is preferred within a period of 45 days from the date on which a copy of the orders appeal against is delivered to the appellate. Appellate authority may entertain the appeal after the expiry of the said period if he has satisfied that the appellant had sufficient cause for not preferring the appeal in time. Next, rule number 26, form and contents of appeals. The appeal shall be presented to the authority to whom appeal lies, a copy being forwarded by the appellant to the authority which made the order appealed against. It shall contain all material statements and arguments on which appellant relies, shall not contain any disrespectful or improper language, and shall be complete on itself. Next, Director and Director General PT Orders. No provision for withholding appeals. Provisions for withholding of appeal has been omitted in the CCS CCA Rules 1965, and all appeals are now to be addressed direct to the Appellate Authority with a copy forwarded to the authority which made the orders appeal against. Submission of proper records with the appeals or petitions in disciplinary. In the interest of expeditious disposal of appeals or petitions in the respect of disciplinary cases, petitions or appeals should be forwarded with the relevant information and documents complete in all respect. While forwarding appeals or petitions, it may be ensured that the following information or records invariably furnished along with them. First one, brief history of the cases, pairwise comments on the appeals or petitions, annexure duly completed, disciplinary file in original, appeal file, service book, CR dossier of the official, any other record or documents relevant to the case. Time limits for forwarding appeals. Punishing authority are directed to forward the appeals to the Appellate Authority promptly within a period of 45 days from the date of receipt of appeal. Review petitions addressed to member of P&T Board and petitions and memorials addressed to the President should be forwarded to the proper authorities within a period of 60 days of the receipt. Next, rule number 27, that is consideration of appeal. In the case of an appeal against an order of the suspension, the Appellate Authority shall consider whether the light of the provisions of Rule 10 and having regard to the circumstances of the case, the order of suspension justified or not, confirm or revoke the order accordingly. Next, rule number 28, implementation of the orders in appeal. The authority which made the order appealed against shall give effect to the orders passed by the Appellate Authority. Thank you for watching. Please subscribe the channel.